Hi, everyone, and welcome back to another episode of Green Jeans. I am your one co-host, Anneke Van Rossum, using pronouns she, her, joined by my other co-host,
Maya Van Rossum, also using pronouns she, her, and wonderfully impressed, Anneke, that you zoomed to the United States Supreme Court for today's episode.
Yeah, so for people who are listening, I have a Zoom background that is SCOTUS. I'm not actually there as much as I want to be. So I'm studying for the bar exam. But yeah, so if you haven't, I zoomed right here because I'm so infuriated. And if you haven't joined our podcast before, we are a mother-daughter duo talking about important social and environmental justice issues through a generational lens. And boy, do we have a show today.
Oh my gosh. Well, it's just like an onslaught of Supreme Court rulings, just sort of taking over literally the world by through decisions from these activist judges, right? At least that's the way I look at it.
Am I crazy, or like, is this, I don't,
well, granted, you need to let people know what this is, because people might not know which of the multitude of decisions you're referring to.
Well, no, I have a general question about all the decisions. This feels like a lot of decisions in a very short amount of time. And is this, in your experience as an attorney and being in the world, is this like weird? I feel like this is a lot at once. And maybe I just haven't paid attention throughout the years.
Well, I think what happens is that there are days when the Supreme Court, releases opinions. And to be perfectly honest with you, I don't monitor or track how quickly they come out or how many, in a bunch. But I think what is striking is that we now have a slew just within the last week, 2 weeks, really, it's been a week.
Like a week and a half, yeah.
An onslaught of decisions that dramatically impact all people, impact fundamental rights, impact inalienable rights, impact the way, how, and if people here in the United States of America literally get to live.
Yeah.
Like how they live, if they live, and whether or not their children or grandchildren, should they choose to have them, have the ability to live.
Yeah. So if you're listening to this, probably the one on everyone's mind is that Roe v. Wade has been overturned. That's the one. But if you haven't seen the other cases, basically people cannot, the other big ones are people cannot personally sue police officers for violating their Miranda rights, even if that evidence was used in court in a conviction against somebody. So that's one. And then today we're going to talk about the EPA case. We'll get into that in a second. But today they also came out with that states can now go prosecute the term is Indians, but non-tribal members on Native American land, which before tribes are sovereign nations and states had no authority to go in there. And now they're like, go ahead, whatever you want to do. So that's the baseline of it all. But we're going to talk about the EPA case.
Well, yeah, except that you forgot one, right? The other one was a case about a New York law.
Oh, and the New York gun law.
The New York gun law, right? Where a law that had been on the books for 100 years, where the state had put limitations on the ability to get a license to carry a concealed weapon. And the court said, essentially, your standard is too broad. You're asking for, I don't know, too much, that a person has to demonstrate that there's a reason why they need to have that right, that ability. And so the court just decided to toss out that law that's been on the books for 100 years. And so now the states are all going to be scrambling if they in fact want to put in place protections. And I think, I actually was, hearing a number of news broadcasts on the day that decision came out. And, just talking about all the places and the spaces where, we believe that there is and should be a limitation on people carrying guns. Mm-hmm. But the way the Supreme Court is just so cavalierly overthrowing protections of all kinds, And when it comes to gun rights, just speaking about the right to bear arms as this overwhelming fundamental fundamental right that should resist limitations that are really important for keeping people safe. I mean, I think that I and others are very fearful about what are the other places and spaces where we now have protections against people carrying weapons, concealed or otherwise, that are now just going to be thrown off the books because the Supreme Court, this very activist, conservative Supreme Court, decides they want everybody to have a gun. And like, so we should they literally said we should go back in time to, when the Constitution was passed and the Second Amendment was added, to decide what if there should be limitations on gun laws. And I think back then, and there have been periods in history where people really are just wandering around with guns everywhere. And I guess we're going back to that.
And I also forgot too. Can't believe I forgot. The coach who was praying on the field, and the Supreme Court basically ruled that you're allowed to now do like prayer at like public schools, which are directly tied to the government, which like goes totally against the whole separation of church and state. And the government shall not do anything to establish a religion, nor prevent the free exercise of it. But that's a whole other thing. But and in that case, it was basically because the coach was fired, but I feel like they made it up. The court made up their reasoning, which they do, and said like, but he was fired because after the school told him to not pray on the field, he was praying by himself in his office, and the school then fired him. So they turned it into so the school violated his free speech, which is just like not what happened. Like, it just wasn't what happened. So also separation of church and state, never mind. And the gun law one is like, you know what? The right to carry a gun, too important, too vital to be left up to the states. We must regulate it as the federal government. But the right to your body and to choose to like not be impregnated, it's fine. States, do whatever the fuck you want with it. Like, I don't understand. Don't get it. But then again, I'm not surprised.
Well, and I'm gonna begin where, frankly, on the environmental front, I think that we end as a result of all this. What is very, very clear is that if we want people to have the ability to drink clean water and breathe clean air, to be entitled to a stable climate, and to be, protected from the ravages of a climate crisis that's being accelerated by dirty fossil fuels and other industrial operators that are allowed to advance because of government, if we want people to be able to have the many benefits of species of all kinds, like pollinator bees, essential for food creation, or places and spaces to recreate that are natural and beautiful, if we want any of those things, then we need very clear, explicit constitutional protection in the Bill of Rights section of our state constitutions, and then an amendment ultimately added to the federal constitution as well, that will protect environmental rights in the same most powerful way we protect gun rights. And we can see with regards to gun rights, when you have that, that language, not only can activist judges grab onto it to do what they want, but activist judges can't undermine it in the same way. But when you have a right like the right to abortion, where it's not explicitly laid out, where it's inferred through the language and through the interpretation of the Constitution in many right-thinking ways. Well, if it doesn't say you have a right to an abortion, then when you get to court, judges can literally wipe it out and take it away. It's, if it's explicitly there, they can't do that. Or they certainly can't do it in the same way. Maybe they can put in place limitations or thing, but they can't wipe it away. So that's where we end up, in my opinion, as a result of all this.
No, and we'll get into, and I think that's like super important, because I think for the lay person who doesn't understand, like Roe v. Wade, the right to abortion is it's not even a right to abortion. It's technically a right to medical privacy when that case went forward. And abortion was like one of the things, just like the same right to like contraception and to Viagra and things like that. So there's never been a right to abortion in the Constitution, which is what Clarence Thomas latched onto and does this whole, well, if the Constitution doesn't explicitly say it, it's not a right. And that's why he's now going on his crazy, we have to go look at overturning same-sex marriage and gay rights and all that stuff, because it's not explicitly stated in the Constitution. It's like arguments under different clauses. So I think that's like, yeah, they haven't done anything to touch the fundamental rights that we have. Unfortunately, that includes the Second Amendment for whatever reason, but like all of the Bill of Rights, they can't do anything to take them away, because those are like, that's a big deal if they did that, and it's not going to happen. So I think
they
can
really they can weaken it, they can undermine it, they can transform it, they can allow, significant limitations, but as you say, they can't wipe it out. Now, let's go to the West Virginia versus US EPA case. That is the environmental case that just came out of the Supreme Court. Now, there, of course, we are not talking about a fundamental environmental right, because that is not explicitly in the Constitution, nor has it ever been interpreted to be in the Constitution. Now, there are lawsuits that have been advancing, over the years, where there has been an effort to get the federal courts to read the rights, climate rights, essentially, or the obligation of government to act on climate into existing constitutional language. But those cases have not gone all the way through to conclusion. They certainly haven't made it up to the Supreme Court. And I think what we just have witnessed in this recent spate of decisions, I think it's, the bar has gotten even higher when it comes to advancing those cases. But so at this point, there isn't, nor has there been at the federal level, a constitutional right to a stable climate or to clean, healthy, safe environment. So we're not talking about a constitutional right, but we are talking about the authority of the US EPA to regulate emissions from fossil fuel power generators, particularly coal, that are climate changing emissions. And we're not going to go into the intricacies, frankly, of what the court said or why it said. I really feel like the court just twisted itself in pretzels. Pretzel twisted, I don't know. But it twisted itself like a pretzel. How's that? To really find a way to say that the effort by the US EPA to put in place regulations that would get these power generating companies off of fossil fuels like coal and on to ultimately clean and renewable sources of energy. The court decided that that was an overreach, that EPA did not have that authority under the Clean Air Act, because what they were seeking to do was sort of change the system of how power is secured, how it is generated, rather than putting in place specific limitations on facilities and how those facilities operate.
Yeah. And so what hurt my brain trying to understand this is that like the original power to regulate, or the original plan to regulate, was under the Clean Power Plan from the Obama administration. And then that whole thing got put on hold. And then Trump amended it with like the American Clean Energy Act or something to basically say like, well, they're trying to the EPA is trying to regulate everybody, but really they should only be able to regulate the physical property. And so that got put on hold. And then I felt like Roberts, or whoever wrote it, I think it's Roberts, said like, because the Biden administration is so pervasive in trying to also secure clean energy, just like the Obama administration, this case is going to happen and these issues are going to happen. So now we have authority to hear it and to do this, even though like neither the Clean Power Plan nor the the Trump era one were like actually like happening quite yet. It's just like a regulation that's sitting there.
Yeah, I mean, I think that you're leading to a very important point that I saw in the case as well, which is the fact of the matter is that the US Supreme Court had plenty of opportunity not to take this case up at all. Because they are focused primarily on the Obama era Clean Power Plan. The Biden administration said very clearly, look, this case is, we're never going to implement the Clean Power Plan. And so there were really two ways for the court to rightly say, we shouldn't be rendering a decision on this. One, for mootness, because they're analyzing a regulatory scheme that the Biden administration has said they're never going to implement. So you're assessing a scheme that's never going to happen. What a waste of time. That's number one. Or number two, for something called standing. In order to pursue a case in court, you have to have someone who's harmed. Well, if the Clean Power Plan is never going to be implemented, then nobody's going to be impacted by it because it's never going to be implemented. So then the court could have said, look, nobody has standing. Nobody has the legal right to address this case. So under either of those two theories, they should have said, this case has no business taking up time in our court.
Well, and
they didn't.
Yeah, they also have like, just because I'm doing bar prep, so it's in my brain. Like one of the things too is like you have to have authority to hear the case under ripeness, which is exactly what it sounds like. The case has to come to fruition. It has to be happening, like, and nothing's happening. So they just kind of, in my opinion, they just kind of made it up. And we're like, well, we want to do it. So here you go.
That's exactly what they did. They had plenty of reasons to say there's no reason to look at this. And yet they said, we're going to look at it anyway, because in our imaginations, even though the government has said very clearly, this is never going to happen, we're actually going to create our own set of new rules, we, the Biden administration. So as you said, the plans that came before are meaningless. Like, why waste time on that? So it's never going to happen. But the court said, well, in our imaginations, we could imagine, essentially what they're saying, we could imagine that the Biden administration is lying.
So I have in SCOTUS blog, when I was trying to read the basic of the case, it says, and in this case, Roberts stressed, because the Biden administration vigorously defends the approach that the Obama EPA took with the Clean Power Plan, the Supreme Court can weigh in. Like, you just made it up.
They just made it up. And then the other thing is the other legal sort of precedent that comes into play here. I don't know if they wrote about it in your SCOTUS blog. I wrote about it in my press statement that I released on this, was that there is something called deference, agency deference. It's from a 1984 case, Chevron versus NRDC. And essentially what it says is look, when you're challenging the way an agency interprets and applies, it's the authority that it's been given by its legislature. Here, Congress at the state level would be at the, by the legislature. How they interpret and how they apply that, either through regulations or through implementation. If there's a case in controversy about that, when we're doing our assessment about whether or not the government agency appropriately acted under the authority granted to it, we will give deference to the agency's interpretation, because they're the ones with the expertise, both in the law and often in the science and in the facts and in how this law could and should best be interpreted and work. And, they have the knowledge, they have the experience. The court doesn't have it, certainly in the same way, nor would a challenger have it in the same way. And so we give deference. Here, there's like no deference. It's just, we don't like what the EPA is saying or doing. We don't like what the Biden administration is saying or doing. So we are going to replace everything they're saying and doing, their whole entire analysis. We're going to replace it with our own personal, political, religious, moral preference. That's what they're doing in this case. That's what they've done in those other cases. that we've talked about. That is genuinely the definition of being an activist judge. You throw out precedent, you don't properly apply the rules of law. That's an activist judge. And that is what conservative legislators rail against all the time. Oh, the liberals are so activist. They're so activist. Bullpucky. This is judicial activism at its best. And they've now done it on women's rights. They've done it with regards to protection from guns. As you said, they've done it with the rights of Native Americans and their sovereign authority. They've done it with regards to the environment. They've done it with regards to civil rights and Miranda. And that's just in the past week and a half, 2 weeks. What are we in store for over the next 2.5 years, over the next, well, many years, until something changes up with this court? We are just slicing down rights, people, future generations that are going to be subjected to the ravages of the climate crisis. It is literally mind-blowing how much damage this court has done in such a short period of time, and what this signals for what we're in for in the coming years if something doesn't dramatically change.
Well, it also, the Chevron deference, that just made me giggle, because like that was like a first case I learned.
It's first year, like
it's first year law
school. It's like the most basic thing, and almost every single environmental case cites this precedent.
Well, and the thing that, like, again, it hurts my brain, because I just am like, I don't get it. Is Roberts goes, so like for people who don't know, like part of the reason there's agencies is it's in like the Constitution that Congress is allowed to create agencies, because Congress can't do everything and can't legislate everything all the time, and the power to create laws and legislation, all that is vested in Congress. So Congress essentially gets to create its little baby agencies and say, here you go, you are experts in this field, you know what you're doing, we're giving you power to regulate. And like there's like some stuff that has to go through Congress and all, but like essentially like we're passing the buck to you, have a good time. And that's what the EPA is federal agency that's allowed to create regulation. And then Chevron deference and all that. And I don't understand, because then Roberts goes on this whole thing and he goes, capping carbon dioxide emissions at a level that will force whatever. He's like, a nationwide transition away from the use of coal to generate electricity may be a sensible solution to the crisis of the day. And then Roberts goes on, but it is not plausible that Congress gave EPA the authority to adopt on its own such a regulatory scheme. That's exactly what Congress created the EPA for, because Congress doesn't have time, and the legislators in Congress don't have time to study greenhouse gases, to read hundreds of pages of scientific reports, to look at graphs, nor do they want to. That's why the EPA exists. So like, I don't get it. Like when I say it's not just because I'm mad, I'm like, it doesn't even make sense. It's literally not true.
They made up so many things. And then they said that this provision of the Clean Air Act, which is the provision that's really focused. So they're basically the Clean Air Act, like the Clean Water Act, like all laws, they sort of have different approaches for handling pollution problems or environmental degradation. And this is the part of the Clean Air Act that's focused on existing facilities. And and essentially what the law sets out is, let's look at what's the pollution, what is the existing pollution in the air, what's too much, how should we regulate what's actually in the air. And then we look at the sources, and we make sure the sources are not putting out so much pollution that they're not meeting these standards we set for what's actually in the air. And there's a level that's focused on hazardous air pollutants, right? Those are the more dangerous air pollutants. And then there's this part that's like, okay, we're going to address what's in the air. We're going to be looking at hazardous pollutants. We're going to be looking at new facilities that are being built, make sure that they're using the best technology, right? When it comes to
which is like
pollution.
not an unreasonable standard. Like that makes sense.
and this is the part of the Clean Air Act that's focused on existing sources, right? So before the Clean Air Act came into play, before it was modified in the 1990s, before various regulations, right? It takes time to develop and hand down regulations, right? There are facilities that have been constructed and gone into operation. And this is saying for those facilities that evaded regulation by these other pathways, we can now go back and make sure that those existing facilities come into compliance with these protective levels that we've set. I mean, it makes perfect sense, right? You don't want to grandfather in all the crap that's already happening, all the bad stuff, because there's a lot of bad stuff. You want to be able to go back, and those facilities that evaded regulation for whatever reason, when they were built, how they operated, when the regulations were passed, whatever reason, you want to be able to go back and bring them up to the same standard as everybody else, which, by the way, equitably, is the right thing to do. I mean, for business operations, it is, and I hear this from developers and industrial operators all the time. I hear this, that it's not fair to put a standard on us that is more stringent than other people who are, who are conducting the same kinds of operations. You have to be equitable. Everybody has to be subjected to the same requirements and standards. That is exactly what this provision is intended to do. And yet one of the excuses the Supreme Court used in their whole rigmarole pretzel twisting decision was this provision of the Clean Air Act had not been used all that much in the past. So now it's suddenly using it in this way is somehow an overreach. So we hadn't used it that much. Now we're using it. So therefore we shouldn't be allowed to use it. Makes no sense.
Well, and they just also Gorsuch is just a hoe for states' rights and for state sovereignty. That's why the one good opinion that he cited on in the dissent was the Native American sovereignty one, because he's like, no, they're a sovereign nation. They should have rights like a sovereign nation. The states have no right to intervene. And this is ridiculous. But in this, because he's a hoe for state sovereignty, he's literally like, yes. And he goes, this raises basic questions about self-government, equality, fair notice, federalism, and the separation of powers. No, it doesn't. It's like you're just making stuff up. And I don't get it. And it is, I understand that there is believe me, being in law school, there's all this these jokes, lawyers are snakes, lawyers don't make sense. And yes, to some degree, there are plenty of people who use the law and rigmarole their way around. But there are also people that are this is the law, this is the way it's written, and we're going to interpret it properly and interpret it to benefit the era that we're in, not make us go back and not make sense. You didn't, it's what if you don't use it, you lose it. That's just what they said. It's so stupid.
I mean, and really, we just have to bring it back to the basic fundamentals. We are facing climate catastrophe. The US is a major, if not the major contributor when you look over history to climate changing emissions. The emissions that we are contributing to the climate crisis, the greenhouse gas emissions, are increasing because of fracking and fossil fuel extraction and the release of methane emissions, right? That is the emission that over a 20-year time frame tremendously exacerbates the climate crisis. That is the emission that we have to corral if we want to avoid reaching the tipping point that takes us over the edge of 2 degrees, more protective 1.5 degrees in terms of a warming climate. The Clean Air Act should be the mechanism by which our government officials can protect us, can protect future generations from the devastating ramifications of the climate crisis, right? Wildfires, heat waves, drought, floods, illness, the vast economic costs. And the interpretation, the EPA, okay, maybe it's not the way that you or I would interpret it. Maybe it's not the way the court would interpret it, but it was a defensible interpretation that made sense. And the court stripped away, and they didn't even just strip away this interpretation. They put in place an incredibly high standard, which is really going to prevent, in no small part, the EPA from being able to take on climate changing emissions unless they can meet this new standard, this new legal test that the court is having be applied under another doctrine, right? Like an old doctrine, but essentially for the EPA to be able to address climate changing emissions, it has to be able to point to, quote, clear congressional authorization, end quote. Do you think in the politics of today, where we don't just have, right, legislators who are denying the climate crisis, maybe because they believe it, more often than not, in my opinion, because their opinion is being bought and paid for by industry, but legislators that are denying that it's real, are denying that it's the result of human activity, or maybe they say, oh yeah, the climate change is real, but it's not a problem, it's part of the natural cycle. We have people like that in having a strong foothold at the federal government. Do you think that there was going to be the passage of any law that clearly the EPA can point to that says this gives us clear congressional authorization to address climate? No, not going to happen. What does that mean? The climate crisis, climate changing emissions coming out of not going to happen. What does that mean? Wildfires, floods, droughts, heat waves getting worse and worse and worse. And what does that mean, Anneke? Your children, should you choose to have them, which you may choose not to, which would be fine, and my grandchildren, should you or them choose to have them, which you may not, which may be fine, or, you know, other offspring, are facing an uncertain, unsafe future. It's just like, it's reprehensible.
That's like the BS too, is it's like, don't force me to birth a kid when you're not creating a environment that I could actually raise a child in. Like, I don't put that on me. That's not my, like, you're killing my planet. And like, I don't want to bring a kid into that. I like, do I feel a little bit of a duty as an activist now that I need to birth like my own personal army of green activists? Yes, a little bit. Kidding, sort of. But like, yeah, it doesn't make sense. And I just don't get it. And to me, it's like that burden too, it read very much, actually, you can tell me if I'm wrong, but to when one of the first Pennsylvania Green Amendment cases happened, that the court was like, if the Pennsylvania legislature doesn't explicitly state that there's a law that the Green Amendment can be used, then it can't work. Like, then it can't be implemented, but only because of a great Pennsylvania Supreme Court justice and a great case brought by you and other attorneys and everybody being like, this law has been read wrong. And a judge being able to overturn that, have we now this immense power in Pennsylvania. And I feel like the court has almost done that here in trying to put a cap on something that's like, you're just reading the law wrong. You're just doing it wrong. And now you've made it harder for everybody else.
And because there's no constitutional check on that power, on that abuse of power that the people can grab onto to challenge what the justices have done, we're left with no remedy. And that's part of the problem. And that is why, you know, having green amendments passed at the state level, okay, it's not going to remedy this court case. But what it will mean is if we can get green amendments in every state across our nation, it means that we will have constitutional obligations on state government authorities, whether it's the legislator, the governor's office, the regulators, the town councils, right? There will now be an obligation on them to address all aspects of environmental protection. And ideally, these green amendments will explicitly mention the climate, which they do in a number of the states where Green Amendments for the Generations is working, right? Climate is explicitly in there. The right to a stable climate and the obligation of government to protect the climate is explicitly in there. So now when we have our government misusing, misreading, misapplying the law, the people can grab on to the Constitution to try and fix it. That's what will happen at the state level, state after state after state. And state governments have a lot of authority when it comes to the environment. At least historically they have. So this really becomes a powerful tool at the state level. And ultimately, when we really start to change the hearts and the minds of people sweeping across the nation, because we've got green amendments passing state after state after state, and people are seeing the immense power and benefit of having constitutional environmental rights, we will be sowing the seeds necessary to ultimately get a federal green amendment. And once we get a federal green amendment, now, I suppose one could say, well, if the Supreme Court reads the Constitution in a way that totally denies and ignores a constitutional right, I mean, like, what do? There is no higher authority. But the truth is, if it's explicitly stated in the Constitution, I really don't foresee that ever happening. On the other hand, I never thought that I would see an insurrection led by the President of the United States. So, but I think that we really, if we can get these constitutional green amendments, we are taking the most powerful legal tool we have, and we're using it to our benefit. And we're stripping away the ability of activist judges like those on the US Supreme Court from really abusing us by taking away our fundamental rights that we have told them explicitly belong to us.
Well, I mean, that's just part of the thing too, is I feel like it's a lot, as much as I don't like it, it's a lot easier for them to do these rigmaroles with like congressional agencies and with arguments under the 14th Amendment of the Due Process Clause and like all this stuff. It's easy for them to do a rigmarole, and I think it's a lot easier for them to undermine things that maybe like everyday people don't understand. But everyday people understand the First Amendment. Every day, you cannot rigmarole your way out of stripping somebody of that. And so I think to have a green amendment in the, like, eventually in the federal constitution, but also like in the state constitutions. And I think, at least from what I've seen from the people in Pennsylvania and the new New York, who are like very aware, like I'll start with New York. The people in New York who voted for that in their Bill of Rights, I'm going to say, good fucking luck taking that away from them. Good fucking luck, because people were jazzed up about it. It got like over 68% voted in. Like, good luck taking that fundamental right away from people. So I can only imagine like having that in the federal constitution, like no Supreme Court is going to touch it. And if they try, like, buildings are getting burned down, just like we're seeing now with things that aren't even necessarily.
But you're not advocating for that.
I'm not advocating for that. No. Yeah, it's actually a good test. I'm saying we're going to see people get really upset and peacefully make their voices heard.
Yeah. And the thing is, right now, because we now know that the US EPA and potentially other agencies at the federal level really now are going to have a very, very difficult time addressing greenhouse gas emissions and the climate crisis, it becomes even more imperative that we do what we can do at the state and local level. And there is a lot, like I said, that can be done at the state and local level, because there's a lot of authority at the state and local level when it comes to the environment and environmental protection. So getting constitutional green amendments that will support stronger interpretation of the laws that are already on the books in those states, and support the passage of stronger laws yet to address the climate crisis and the other ramifications. Because remember, climate changing emissions aren't just exacerbating the climate crisis, they also harm human health and inflict other impacts on people and the environment. And so when we address those emissions for the myriad of reasons that they cause harm, we are also helping to address the climate crisis. So just more, we need to do more at the local level and at the state level. And I think that, one of the most important empowering things that we can do to have broad change, not a little regulation here or another gap filling law there, but big, broad change across the state, across state after state after state is the passage of constitutional green amendments. So, and I think today the decisions out of the Supreme Court, whether it's about the EPA or whether it's about the women's right to control her own body and access appropriate health care, solidifies the power and importance of explicit environmental rights and climate rights being added to our state and federal constitutions.
I agree. And I think that's a perfect wrap up. So yeah, get involved in the Green Amendment movement, guys, if you took nothing else away from this episode. But yeah, go to www.forthegenerations.org. You can also go to the little link that will be in the description below to maybe pre-order the second edition of the Green Amendment book coming out this November. You can always make a little fancy schmancy donation to Green Amendments for the Generations, also linked below. My arm is disappearing. But yeah, I think that's it. So we will see you next time.
See you next time.